Good day everyone. Today, the Group 2 is going to present about the topic copyright law.
This presentation is going to be presented by Decamos, Espolgar, Fulgencio, Gatilogo, Giliergan, Escolar, Esteban, Ganon, Gayongorsa, Cordoves, and Asildo.
What is copyright? The legal word copyright, often known as author's right, refers to the ownership rights that authors and artists have over their creative works, books, music, paintings, sculptures, films, computer programs, databases, ads, maps, and technical drawings are among the works that fall under the purview of copyright protection.
Types of rights under the law of copyright. Economic rights. This implies that the sole authority to decide whether a work is translated into another language, altered into a different format, communicated, recorded, or performed in public belongs to the copyright holders. Moral rights. A work's moral rights belong to its creator and cannot be altered or distorted. These rights, which include the ability to stop a work from being connected to a certain good, cause, or organization, can be discontinued through formal agreement. Resale rights, known as droit de suite. Artistic rights entail royalties from the selling of an artist's work, and the artist or their hirer's participation in the revenues. Related rights. Related rights refer to the rights of those who assist the author in producing and distributing their work to the public.
These are considered copyrightable works in the Philippines. Section 172 of the IP Code lists the works covered by copyright protection from the moment of their creation, namely books, pamphlets, articles and other writings, periodicals and newspapers, lectures, sermons, addresses, dissertations prepared for oral delivery whether or not reduced in writing or other material form, letters, dramatic or dramatical musical compositions, choreographic works or entertainment and dance shows, musical compositions with or without words, works of drawing, painting, architecture, sculpture, engraving, lithography or other work of art, models or designs for works of art, original ornamental designs or models for articles of manufacture, whether or not registrable as an industrial design and other works of applied art.
Copyrightable works in the Philippines also includes illustrations, maps, plans, sketches, charts, and three-dimensional works relative to geography, topography, architecture, or science. Drawings or plastic works of a scientific or technical character. Photographic works including works produced by a process analogous to photography, lantern slides. Audiovisual works and cinematographic works and works produced by a process analogous to cinematography or any process for making audiovisual recordings. Pictorial illustrations and advertisements, computer programs, other literary, scholarly, scientific, and artistic works.
What is not protected by copyright under the Philippine law? Here's a list of things not protected by copyright under Philippine law. First, idea, procedure, system, method, or operation, concept, principle, discovery, or mere data as such, even if they expressed, explained, illustrated, or embodied. Next, news of the day and other miscellaneous facts having the character of mere items of press information. Next, official text of a legislative, administrative, or legal nature, as well as my official translation thereof, work of the Philippine government, unless there was a prior approval by the appropriate government agency and statutes, rules, and regulations. Read speeches, lectures, sermons, addresses, and dissertations pronounced, read or rendered in courts of justice before administrative agencies, in deliberative assemblies, and in meetings of public character.
Is a copyright registration necessary to protect artistic or literary works? Copyright registration formally certifies one's ownership of copyright as it is a public record. Therefore, a copyright registration aids in the facilitation of transactions like licensing, sale, and assignment that involves the ownership and transfer of the copyright. In many countries, copyright registration is automatic upon the creation of artistic or literary works. There are various advantages to copyright registration.
Copyright registration formally certifies one's ownership of a copyright as it is a public record. Therefore, a copyright registration aids in the facilitation of transactions like licensing, sale, and assignment that involve the ownership and transfer of the copyright. In many countries, copyright registration is automatic upon the creation of artistic or literary works. There are various advantages to copyright registration. A public record of your copyright claim is established when you register a work with the relevant authorities. This can be important if there is a disagreement over enforcement of your rights. Also, it grants the author the right to prevent others from using their creations without their consent in a variety of ways. Examples of such uses include copying, sharing the work online, renting or lending but not for public use, organizing or changing the work. This enables us to pursue legal fees and statutory damages in court in the event that someone violates your copyright. Copyright registration can greatly improve your position in cases of infringement, even though it is not necessarily required for protection.
Who can apply for a copyright registration? Everyone can be a copyright owner and can apply for a copyright registration. In Rule 2, Section 1 of the Rules and Regulations on Copyright Registration and Deposit, it was stated that the author or creator of the work, his heirs or assignee, may apply for a certificate of copyright registration and deposit. They may apply in person or through a duly authorized representative. Non-resident applicant may be represented by a duly authorized resident agent. To that end, it guarantees that the rights to their intellectual property are legally acknowledged and safeguarded by the copyright law by outlining the steps and choices open to people or organizations seeking for copyright registration and deposit.
Who are considered owners of the copyrightable works? Copyright law protects copyrightable works, granting exclusive right to their creator or owners. The creator is the initial owner, while an employer usually owns the copyright if a work is created by an employee within their employment scope. If a work is created by an independent contractor with a written agreement stating it is made for hire, the commissioning person or organization owns the copyright under specific conditions. If two or more authors collaborate on a work, they are considered joint authors and joint owners of the copyright. If a creator sells or transfers the entire copy to another entity, the purchaser becomes a new owner. Licenses have certain rights but do not become full owners. In case where an original author passes away or assigns the rights to another party, heirs or assignees may become owners of the copyrighted works.
Conclusion. In the realm of nursing informatics, understanding copyright law is crucial for safeguarding intellectual property while embracing technology's benefits. Nurses must understand policies, guidelines, and legal frameworks related to copyright protection. Acknowledging ownership rights in copyrighted works is important. Nurses creating resources, software solutions, or research publications must be aware of copyright holders and any usage permissions or restrictions. Though not mandatory, copyright registration can help nurses establish ownership and address infringements effectively. Understanding copyright law empowers nurses to innovate responsibly, respect intellectual property, and contribute to healthcare technology advancement. Adhering to copyright policies ensure ethical and legal use of materials in professional endeavors.
The following are the references used by the members in this presentation. Thank you for listening, and we hope that you've learned something from this presentation.